All right. Hello again, Avengers, and welcome to another exciting daily vlog. This is Daily Vlog 2025, number 118, and today it's time to revel in the drama. Uh, I'm generally not a big fan of dogpiling on drama, but this particular thing, uh, I believe there is something we can learn from it. And it's not so much, and what did we learn? It's more of, I want to talk about a particular form of civil tort, which we will discuss what that means in a second, that a lot of people don't realize is a thing. And I think it's fairly obvious in this particular interaction. The people involved in this had no idea that what they were doing actually violated common law. And theoretically could open them up to lawsuits. I'm going to preface this with the idea that I am not a lawyer. I have never been to law school. I have a business degree in marketing management, and part of that degree required me to learn some business law because my degree is a management degree, so I'm supposed to be able to run businesses. In order to run businesses, you have to understand business law. I'm also going to point out this is my personal understanding of an extremely complicated situation. And I'm not going to be talking about the entirety of the situation. I'm going to be talking about one specific action that was done, or I guess a couple specific actions that were done that I believe illustrates, make a good illustration of a specific common law tort that other people that run businesses could very easily fall into the problem of dealing with. So this is not legal advice. This is not meant to be used in any way, shape, or form to form a lawsuit or anything like that. This is me talking about a specific type of business law and using a real world example of something that could theoretically, in my opinion, have violated this this common law. So, sorry, I've got some stuff in my throat and it's just messing me up. It has been just a hell of a day thus far. I was shaving today. I somehow nicked my nostril and it proceeded to bleed like I nicked an artery for like half an hour. So let's talk about tortious interference. If you've never heard that term before, effectively, in pure layman's terms, tortious interference is where one business interacts with another business to try and stop or hinder a third business from doing business with this second business. The way that it's explained, I have a couple different websites open. One of them is the Westlaw Dictionary. And that specifically talks about tortious interference and the two kind of different flavors of tortious interference. And the other one is specifically from a website called Coffee Law, which is an actual law firm. And when they try to give examples of tortious interference, they name them companies A, B, and C to make them as simple as possible. So that's what I'm going to use moving forward. Company A is going to be the company that is committing the tort. That is definition here from Coffee Law. A tort is a civil wrong as opposed to a crime, which is a violation of criminal statute. So this is a civil problem, not a criminal problem. Meaning if things go poorly for one party, they're not going to be going to jail. They're going to be fined and penalized. Now, if they don't pay those fines, eventually you can get to the point where you can be criminally charged for refusing court orders and things like that. But this particular thing, it is not a crime. It is a civil tort. So that being said, what am I referencing? Well, there's been a huge amount of drama in the Vtuber community, specifically around a Vtuber named Cinder. And I'm not going to get into absolutely everything that went on. About a billion other channels are covering that, and I'm not here to really cover the drama. I'm here to cover business law. Effectively, what happened was, or what is alleged, is Cinder was kind of doing some whisper campaigns. Cinder and their manager / significant other were doing some whisper campaigns behind the scenes to kind of sabotage the careers of a few other VTubers. You know, your standard kind of high school bullshit. However, where we start kind of flirting with the idea, where we possibly start, in my humble opinion, flirting with the idea of committing a civil tort, is when we talk about this artist that I can never remember their name. So let me see if I can actually get their name. Again, something about my brain just doesn't like proper nouns, so I had everything. Okay, so Nanoless. That is the person that started all of this drama. And by started all of this drama, I mean actually came out and told us what was happening. So anyway, Cinder, through their manager, my understanding, Cinder, through their manager, Redacted, otherwise known as Red, basically was claiming that they were trying to get an exclusive contract with this artist, Nanoless. And if anyone's wondering what any of that has to do with being a VTuber, so being a VTuber, you have to have an avatar, and there's two like really, really important people involved in, you know, having an avatar. You have the artist that actually designed the avatars, and you have your rigger, who's basically the one that kind of puppets the avatar and makes it connect with the software that you use so that it mimics your movements. We are specifically talking about an artist, not a rigger, as far as I understand. So, something that happens regularly with VTubers is they will get new avatars, like I said, fairly regularly. For a number of different things. Your new avatar might have a new costume, or you might try to like update the design so you can have like a different look. Or you might have a holiday themed avatar, or anything like that. It happens a lot. And the thing with VTubers in general is a decent amount of, at least big VTubers, a decent amount of their income is going to come from merchandise sales and things like that. And every time there is a new avatar, there is a possibility for new merchandise sales and the things like that, because it's a new thing. It's the same thing if you grew up in like the 90s like I did, or the 80s like I didn't, but I was alive then. I was just 1 and 2 years old. It's the same thing when a new action figure of the same character comes out. You know, if you're looking at like Beast Wars, there was the original Optimus Prime, and then Transmetal Optimus Prime, and then Optimal Optimus. It's the same damn character, it's just different flavors of them, and all of those made more sales. So the same basic thing can happen. I'm not saying that is the sole purpose of getting new avatars and stuff like that, but it is a significant financial investment, and it can turn into significant amounts of profit. Wow, brain not working. So, again, as far as I understand, according to the allegations, blah, 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 legalese, Cinder claims that they were trying to get kind of an exclusivity contract with Nanoless, so that Nanoless would be, again, the entire purpose of an exclusivity contract is I'm going to pay you extra so that whatever you make is mine and mine alone. That's how exclusivity contracts work. and they're relatively common. And there's a number of benefits to exclusivity contracts and a number of drawbacks. The biggest benefit for the person paying for the exclusivity contract is whatever thing they're getting exclusively from this supplier, they can claim, oh, I am the only place you can get this particular thing. It's really, really common with retail chains and the things like that. Where you see things, oh, you can get this exclusively at Barnes & Noble or exclusively at Walmart. It means that anyone that is going to purchase this product or view this product in the case of like VTubers, the only place that they can view it is through here. And by having an exclusivity contract with an artist, artists have their own style, they have their own signature, basically. When you get really familiar with a style of art, you can pick out an artist's painting simply by going, oh, obviously that is this particular artist because they do this, this, and this, and this. And these VTuber artists have followings. They have fans and things like that. So there would have been some significant financial benefit towards Cinder to get an exclusivity contract. Now, the benefits for an artist to become exclusive, generally it means that they can charge more for effectively the same kind of service because they are also agreeing to not work for anyone else. So because of that, there's a premium fee associated with that. And different exclusivity contracts work in different ways. So the idea of Cinder attempting to get some sort of exclusivity contract, that's not where the civil tort comes from. The problem is, despite the fact that this is how it's been described, what the actual notifications show and the messages and things that have all been showed is not an exclusivity contract. It is a tortious interference, in my opinion. And the reason why I believe that this could be tortious interference is because instead of going, hey, I want you to exclusively work for me, they go, hey, I don't want you working for these particular people. And I believe, and feel free to correct me if I'm wrong on any of the kind of minutia in this particular instance. Again, the purpose of this is not so much to focus on this drama thing, but to talk about tortious interference, and this is a really good example, in my opinion. Red had mentioned, hey, we don't want you working with these particular people. And if this person asks you to do something, just tell them you're busy or something like that, and we will actually pay for the commission that you didn't make. So you're not going to lose any money. We just don't want you working with this particular person. And that's where the civil tort occurs. Again, an exclusivity contract is not illegal or immoral. It's just a way to do business. But one company, Company A, contacting another company, Company B, and saying, hey, we don't want you to interact or have a business relationship with Company C, is a tortious interference. It's not fair to do that to other companies, and it opens you up to the possibility of lawsuits. Now, tortious interference is a bit complicated because specifically there's a bunch of different things that you have to effectively prove in order to be able to even file the lawsuit. And again, there's two different flavors of tortious interference. And I'm going to do. There is tortious interference with contractual relationships, which, depending on the jurisdiction, kind of gets called different things, but it's basically tortious interference when a contract already exists between Company C and Company B, and Company A encourages or causes company B to break that contract with company C. So that's interference with contractual relationships. The second flavor is interference with prospective economic advantage. And that's basically, well, company B and company C don't actually have a contract, but they have a business relationship, they know of each other, and there's a possibility that they might form a contract eventually. So there are two different flavors of tortious interference. And because of what happened in this particular instance, as far as I'm aware, they were actually able to violate both of those. Because specifically when we talk about a VTuber named Bao, my understanding with Bao was Bao had hired Nanoless to create a new model or avatar. I don't know the terms in the VTuber community. But Bao had actually started going through the process of having Nanoless create this new avatar for them. And had actually gotten to the point where initial kind of concept sketches had already started trading places. So at that point, whether or not there was a written contract in the business world, as soon as you're getting to the point where money's starting to exchange hands or specific details are starting to be put back and forth, you can make an argument for having an implied contract, even if there was nothing officially signed. Especially if any kind of money changed hands, like if there was, and this is stuff that I'm pure speculation. I have no idea how Nanoless works. I'm just saying, any time money changes hands, a contract is effectively implied. You are exchanging goods for a service, and therefore you have to fulfill whatever it was that you were paid for. Money changing hands is really a big deal when it comes to law. Because up until the point money changes hands, people can claim, well, I wasn't planning on it, I was just feeling it out. As soon as money changes hands, that is grounds enough for most jurisdictions to say, no, there is intent for this to actually go through. That's why things like down payments exist and stuff like that. As soon as money changes hands, legally, everything changes. I have no idea if any money changed hands between Bao and Nanoless. I don't know how Nanoless does their work. I'm just saying, if money changed hands, there was definitely a bare minimum implied contract, if not an actual contract that was signed. If money didn't change hands, but again, sketches and things were being sent back and forth, again, you could very easily argue for the idea of an implied contract or something along those lines. In addition to what happened to Bao, Cinder allegedly, apparently, as far as I am aware, also had other creators on this blacklist that they effectively gave to Nanoless that may not have worked with Nanoless at that point. But again, Nanoless is a huge name in the VTuber community. So there is a good chance that they eventually would have worked with her because all of these people were relatively big name VTubers. And they all worked together. I think there was only one person that was named on there that I'm aware of that didn't technically belong to this little in-group of VTubers that collaborated together and stuff like that. And effectively, again, as far as I'm aware, allegedly, legalese was targeted because her avatar theme was somewhat similar to Cinder's. So... For proving a tortious interference claim, depending on which flavor you're talking about, for the interference with contractual relationships, you need both of these you need four things. For the interference with contractual relationships, the 4 points that you need: you had a valid contract with another party. And again, that can be the breaking point for a lawsuit. If you bring a lawsuit against someone for tortious interference with a contractual relationship, and they're able to prove that there was no contractual relationship, it doesn't matter if the other 3 points are met. Your lawsuit fails right then. And because the lawsuit was for that particular tort, the lawsuit goes away. Even if you can prove the second one, the tortious interference with prospective economic advantage. If you sued under the first one, you don't get to go, oh, well, what I meant was... now, again, lawsuits and the law are very, very complicated. There's always a chance that the judge would allow you to amend your complaint to the other flavor. But the best thing that you can do if you're filing a lawsuit like this, again, not a lawyer, if something like this is happening, talk to someone with a legal degree, preferably someone with a legal degree and who belongs to the bar in your area. Not bars I'm talking about the legal bar that allows lawyers to practice law. Talk to someone that actually knows about this. So yeah, you need to make sure that you're suing under the right to the tort, or you're going to run into problems. So first, you had a valid contract with another party. The second one, the defendant, so Company A, had knowledge of the contract. So you have to be able to prove that Company A knew that you had a contract with them, because simply saying, hey, I don't want you to work with this person does not count as interference with contractual relationships, because they may not know that you have a contract, and simply telling a company, hey, I don't want you working with this other person is not in and of itself illegal. The steps that you take to make that a reality can eventually turn into a civil tort. So the defendant had knowledge of the contract. That's number 2. 3, the defendant acted intentionally and improperly. This is another really big stumbling block. If Company A can say, it was never our intent to make them stop working with this company, we simply were trying to get them to put our particular project higher in their production order so that they would work ours first. We had no idea that by prioritizing ours that it was going to cause problems for this other company. That wasn't our intention. Congratulations, the tortious interference claim is gone. So you have to be able to prove that they acted intentionally and improperly. That it wasn't just business, that it wasn't a very common practice in the industry in general. Things like if you have if you have a rush order system where someone can pay additional money to basically be bumped up the list, you can't use the fact that they use this readily available system, and that unfortunately caused your contract to come out late or something like that. They have to have acted both intentionally and improperly. They had to have done something wrong. And then the fourth part is your business was harmed by the defendant's actions. So you have to be able to show that directly because of what Company A did, it harmed your business. And in general, harm in law means how much money did you lose. You have to be able to put a dollar amount on it. Now, there are some it's actually relatively common for lawsuits to go damage or the harm caused is damages to be proven at trial, where they basically say, yes, it did cause us economic damages. We are not going to put a specific number on it in our initial filing because we want to be able to prove in court exactly how damaging it was. And there's a bunch of different benefits to doing that, including the fact that you have significantly more time to figure out exactly how much damages you can claim. But you do have to, at least at the initial accusation phase, you have to go, yes, my business was harmed. And in legal talk, your business was harmed has to have a dollar amount. Now, the fun part about, it has to have a dollar amount. It doesn't mean that your business had to actively lose money over something. Like we see it in things like defamation cases and things like that, and libel cases. You don't have to prove that because of what they said, you actively lost money. Like you had $1,000 today and then they said something and now you only have $500. What is extremely common is you can go, well, our numbers were going up at this point. They said something and they plateaued or they started going down. So that is economic harm, because if we look at the trend it was going, if the trend had continued, we would have this much money, but now we have this much money. So this area in between is our damages. So it doesn't have to be you actively lost money. It can just as easily be we had the possibility of making this much money. And because of what they did, we made this much money, so they have to pay the difference. And that's one of the big reasons why a lot of lawsuits will say damages to be proven at trial. Because when you get to the trial, even after the defendant is found guilty or whatever, they may still argue going, well, yes, we were guilty, but what they're claiming is a nonsense number. There's no possible way they ever would have made that much money. We are going to fight on the amount. So, because it's all imaginary money and stuff like that, that can be flexible. But if you have someone that has any like basic understanding of how to run a business, they will be able to at least give a number to the lawsuit without too much difficulty. Like part of running a business is being able to speculate where your business is going to be in a few months. Like part of part of a business plan. Remember when we talked about business plans and Kickstarters and all that stuff? Part of a business plan is you basically have to present to the bank, where is my business going to be doing financially in a year, in 5 years, in 10 years? Tends to be really, really common. And sometimes they'll throw a 3-year mark in there. But 1, 5, and 10 tends to be really, really common in a business plan that you're applying for a loan for. Because your loan, more likely than not, is going to be a minimum of a 5-year loan. A lot of times it's 10 or 20-year loans for these things, because it takes a while for you to be able to actually earn enough money to pay off your loans. So anyone with any business knowledge will be able to go, oh, sure, we were here, we were planning on, making these particular, like if we go back into this Vtuber thing, we were planning on it premiering here. The last time we premiered a new avatar, we saw an increase of this much in donations and this much. We were planning on making these particular products. The last time we made these particular products, they sold this much and this much and this much. Like those numbers are really, really easy to come by if you have someone that understands how your business works. So that is interference with a contractual relationship. If we go with interference with a prospective economic advantage, which is, again, they don't have a contract, but they could, these are the 4 things that you need. 1, you had a business relationship with another party, even if that relationship had not taken the form of a contract. So company C has to be familiar enough with company B that they already have some sort of business relationship. Now, the term business relationship is varied. That's where things start getting kind of murky. And that's where having a really, really good lawyer is going to help you. But in situations where you've had conversations, specifically if you can show, hey, I've had conversations where I've said, hey, I'd really be interested in you creating an avatar for me, that creates a business relationship right there. Just enough for you to go, hey, I'm interested in you creating an avatar for me, and them replying back in some way, shape, or form, hey, yeah, that'd be cool, but I'm busy for the next 6 months, 2 years, whatever. That in and of itself is generally enough to go, yes, we had a business relationship. I had inquired. Second thing, the defendant knew of this relationship. And again, this is where things can fall on its face really, really quickly. When there's no contract or anything proving that they knew that you were thinking about having a contract, that gets murky. And again, this is where a really good lawyer helps out a lot. Now, if there are, I don't know, text messages or Discord messages, things that show you talking about how you intend to go to this particular artist and get something from them, then there's really no question that the defendant knew of the relationship. But if you don't have those things, then things can get very, very difficult. Third, the defendant intentionally and with wrongful means interfered with that relationship. Again, this is a two-part thing. Intentionally, you have to be able to prove intent, and proving intent is remarkably difficult. It's one of the reasons why defamation lawsuits are so incredibly difficult to win. Because depending on, especially if you are considered a celebrity or a quote-unquote public figure, you have to prove malicious intent. You have to prove that what they said they intended to be malicious. The entire purpose of them saying what they said was to hurt you personally. In this, you don't have to technically prove quote-unquote malicious intent, but you have to prove they intended to interfere with the relationship and with wrongful means. Again, if they're doing something that is just a standard business practice that just so happens to interfere with your ability to work with this company, you're probably not going to be able to get a tortious interference. Even if their intention was to stop you, if it simply was, an exclusivity contract. If they had gone and seen that you wanted to work with this person and they convinced them to sign an exclusivity contract, the net results is exactly the same as what happened here. You're not getting your avatar. However, exclusivity contracts are legal and completely acceptable. So if that's what had happened, they wouldn't really have a claim here, in my humble opinion, allegedly, legalese, save my ass. But if you can go, no, what they did was wrongful. This is not the way that you deal with this. If they specifically named you, or if they said things like, hey, listen, if they try to get a commission from you, tell them you're too busy and we will pay you to make up for the lost revenue. That's not something you can do. That is a tortious interference. If something like that happened. I'm not claiming that is exactly what happened. I'm saying if something like that did happen, then the person that had been wronged might have a case for a tortious interference claim. And then the fourth part of a tortious interference with prospective economic advantage is your business suffered harm as a result. So again, you have to be able to show that you suffered harm, and specifically your business. It can't be you personally. It's like, my feelings got hurt and that made me feel bad. That's not a business thing. Even if effectively you have like a sole proprietorship style business where you and the business are basically indistinguishable from each other, physical harm or mental harm to the owner of a business does not translate as the business suffered harm. You have to show economic harm. You have to show that because of what happened to you, the business lost money. And again, there's a bunch of different ways to prove that. Even if it was just like emotional damage, even if it's just like you had to take mental health days, you can sit there and go, well, I wasn't able to work on these particular days. I normally would have earned this amount of money, but I wasn't able to do that, and therefore that is the economic harm that resulted in my resulted from their tortious interference. Yeah, they have here some examples of improper conduct. And again, this is from Coffee Law or Kofi Law. I don't know how they pronounce it. But this is the examples that they give. They're not coming from me. This is coming from a website. It's coffeelaw.com. Some examples of improper conduct include the use of fraud or misrepresentation, trade libel, trademark infringement, blackmail, economic pressure, initiating civil lawsuits or criminal prosecutions, and even physical violence. So, that is tortious interference. So the reason that I got inspired to do this is one of the phrases that keeps kind of floating around, because it was allegedly used in some of these messages, was it's just business. No, it's not. This is something that a lot of people misunderstand about business in general, especially people that are like the anti-work crowd, or the people that are like, eat the rich and all that stuff. They have no idea how actual businesses run. And so they just assume that anyone that is in a position of authority in a business, and I saw this with my friends when I was younger and had actual friends that I spent time with. I remember sitting around at a friend's house, and we're all just kind of shooting the shit. Everybody had shitty jobs. Like, we're all working in retail and stuff like that. However, because by the time I got into retail, I spent exactly 5 months in retail before I got promoted into management. Because I was real good at what I did. And a position opened up because we had an employee. Let's just say that employee stopped working for the company, and not because they wanted to stop working for the company. We'll put it that way. I also remember one employee being let out in handcuffs, but that's a completely different story. So there was a position open. I was put into it, and then I did exceptionally well. So I'm sitting around talking with my friends. We're just shooting the shit about jobs and stuff like that, and they're going to start bitching. He's like, God, managers have it so easy. They're all so fucking lazy, and they don't do a goddamn thing. They just sit on their asses all day. And I just turned to them and goes, you guys have no idea what you're talking about. I said, what do you know? I said, because I'm a manager, dipshit. Yeah, but I said, I pull 12 to 16 hour shifts. I don't get lunches. I don't get breaks. I get yelled at, spit on, shit on. And if I ever lose my cool, if I ever yell at an employee, I can lose my job instantly. Do not pass go. Do not collect $200. I have had employees spread rumors about me sleeping with employees to get me fired. I've been investigated for racial discrimination, none of which I did. They lied through their teeth to try and get me fired, and there was nothing I could do about it. Being a manager sucks. And that's on top of the fact that anytime an employee does something wrong, the manager is the one that gets yelled at about it first. Unless we catch you doing something wrong, I was forced to sit in on sales calls where my store wasn't meeting sales. Through no fault of my own, another manager had gone behind my back and stopped my employees from using the techniques that I taught them, and it effectively sabotaged the entire store. The fun part about that was completely unintentional. He was just a moron, didn't realize that he was sabotaging something I'd spent 9 months trying to fix. He was just stupid. So yeah, there are a lot of people that just don't understand that it's not just business. That's not actually how a business runs. Management is not an easy position. It has extremely high rates of depression, anxiety, and slewer things that end with side in it. Yeah, it's a really rough position. And the idea that it's just business when I'm actively sabotaging another business, it's not just business. It's a civil tort. It's I don't know if you can. I don't understand the law well enough to be able to say specifically if you're allowed to call that illegal, because it's not against a law that has been passed by any sort of Congress. It's a common law thing. It's a civil tort. So I don't know if you're allowed to call it illegal, but it is a violation of common law. So if that also equals illegal, then yes, it's illegal. Otherwise, it's a civil tort. And can, like, the damages that you can get from it. First of all, effectively, you can get them to pay for all of your economic damages. So basically, you know that thing where it says damages to be proven at trial. You can effectively at trial and say we lost this much money in profit. We had to spend this much money filing this lawsuit. And there's a possibility that because of this, we're going to lose this much additional profit from it. That's all compensation for economic loss. Whether or not you're going to be able to put in like your legal fees and stuff like that, I think it depends on the jurisdiction. I don't actually know if you can get them to pay your legal expenses. Sometimes you're just kind of screwed for that, which is why in some instances, even if there is a measurable tort or something like that, they won't take it to good court simply because the amount of money it'll cost them to get the judgment will be more than they will make from it. The other thing that can happen is you can get punitive damages added on. And this is again from Coffee Law. Punitive damages if the plaintiff can be shown to have acted with, quote, oppression, fraud, or malice, end quote. And then you can also get injunctive relief. So punitive damages is basically in addition to the economic loss that they're going to compensate you for. They will also be required to pay a set amount as a punishment. You did something wrong, so in addition to having to pay for what they should have made, we're also going to force you to pay a punishment amount. And most jurisdictions will have like upper limits about what they're allowed to charge in punitive damages. Like if you remember the Johnny Depp defamation trial from years ago, the jury awarded Johnny Depp like I want to say it was like 6 or 7 million in punitive damages or something akin to that. I can't remember specifically. And then the judge lowered it down because there's an upper limit for what you're allowed to charge for punitive damages in most for most crimes. There will be an upper limit. So as far as what punitive damage that they could pay, again, that's a court thing. I have no idea. I also, and this is something that if somebody actually knows, and I'm not like, oh, I heard. I mean, if you actually have legal knowledge, feel free to put this in the comments. I don't know if the punitive damages are paid to the court or if they're paid to the defendant. Again, I've never been involved in a lawsuit like this, so I don't know where all the money goes. So if the punitive damages also go to the defendant, that's a thing. If they just go to the court, that's a thing as well. I don't know. And then injunctive relief is basically, it's a cease and desist order. If what they are doing at that point is preventing you from doing something, a cease and desist or injunctive relief in general is basically them saying, yeah, and now you are legally barred from doing this anymore. If you attempt to do this, you will be in violation of a cease and desist order, which I believe does start to get into criminal. I'm not 100% sure. So just look. So according to the AI, a cease and desist order issued by a court or government agency is legally enforceable, and violating it can lead to criminal penalties, civil contempt, or other legal repercussions. So theoretically, you could be charged with something like civil contempt, which is again civil, but it could also be considered a crime. I don't understand how it is. I don't know what it takes for it to go from civil to criminal. And like I said, the big difference between civil and criminal is civil costs you money, criminal can send you to jail. And will also cost you money. Like criminal penalties include monies, but criminal things also will send you to jail. So anyway, like I said, the entire reason I wanted to film this video was not so much to have a commentary on how horrible a person Cinder is or anything like that. I specifically wanted to focus on that idea of, well, it's just business. No, this isn't just business. This isn't how business works. And if you think that this is something that you can do once you become a large enough force in a market that you can actively start attacking other competitors in your market, you are going to run into issues because you're going to run into this. And if you do it enough, you eventually can get charged with what's happening with Alphabet right now and Meta, which is you eventually have to deal with antitrust lawsuits, which are criminal. And antitrust is effectively when you use your market presence to bully other competitors out once you have a large enough share of the market. So small stuff like tortious interference can turn into large stuff if you are significantly large enough in the market. I don't think there's a single quote-unquote Vtuber that could ever be charged with any kind of antitrust lawsuit. Simply because I don't think there's a single VTuber that would be able to corner enough of any part of that market to be able to be charged under that. But the idea of tortious interference, that's not just business. That's not how businesses run. If you are aware of a business that you work for doing something like this, what they are doing is not just business. It is a civil tort and to be blunt, should result in that business getting sued and fined. It's not okay. And it's not just business. This isn't how businesses run. Good businesses don't need to do this. And bad businesses that do things like this don't last very long. Because if the only way that you can keep your share of the market is by intentionally sabotaging your competitors, you will eventually run out of money to be able to do that. From an economic standpoint, this type of business is not viable. And as we've recently seen, it doesn't work as soon as people find out about it. The only way something like this works, and it was one of the other things that I found really, as horrible as it sounds, because this is a really, really tough, difficult situation for everyone involved. But when I'm not the one that's getting hurt by it, it is relatively fascinating. The steps, because I've read through a few of the messages and the things like that, and my understanding, allegedly legalese to cover my ass, they were rather blatant with their statements. I mean, they made it very, very easy to bring up one of these lawsuits if all of these things actually did happen the exact way it has been described. Allegedly, blah blah blah. This is not legal advice. Do not use me in your lawsuit. They were blatant about it. And my personal belief and theory as to why they were so blatant is they had no idea that this was wrong. They thought it's just business. I'm big enough. I can do what I want to ensure that I will remain on top. And you can't. That's not allowed. It's not legal. And there's a lot of other things. Again, I had this conversation with my friends, and they had this strange idea of what managers do, and I'm like, that's not how it works. If I ever had a single day where I acted in the way that you guys claim your managers act, I would not only be fired, I would be sued. Because sitting on your ass doing nothing and getting a paycheck for it can be considered what's called wage theft. And I have seen companies prosecute for wage theft. And that is not a civil tort, that is a criminal prosecution. And it's not pretty when you have to deal with it. So yeah, like I said, a lot of people think, oh, that's just business. Business is unethical. No, there are tons and tons and tons of studies that show ethical businesses make significantly more money than unethical businesses. That unethical practices, while they may give you short-term gains, over the long term will sink your business. It's the same thing as the idea that salesmen are inherently dishonest. They're not. The vast majority, and I mean upwards of 95 to 98% of salesmen, are the most honest people you will find in a store. And again, there have been tons of studies that have been able to prove this. Salesmen are remarkably honest for the most part because if they tell a lie, first of all, there's a bunch of different laws that protect consumers from businesses that lie to them. They're called fraud laws. And if you can get caught saying something that is not true and it causes someone to make a purchase, that is fraud and you can be criminally charged. It's real bad. The second reason is when a salesman lies, they have to deal with the consequences. When the customer comes back in and gets all mad at them, there's not a whole lot they can do other than try to run to their manager and hope their manager will have their back. Fun fact, most managers will not protect a lying salesman. No matter how good they are, it's not worth their job, because as soon as they start protecting him, the fraud lawsuit goes from the employee to the manager, and then they lose everything they have and can never work in the industry again. So yeah, this isn't how businesses work. And there are tons and tons and tons of laws and common law that protect consumers and businesses from this kind of stuff, like tortious interference lawsuits. The world of business is not nearly the kind of Wild West, lawless community that a lot of people that have never run a business before or never run a business well think it is. There are so many laws in place that protect consumers. There are so many laws that protect employees. There are a few laws that protect managers and business owners, but not anywhere near as many as there are for consumer protection and employee protection. And there's a lot of laws that protect small businesses from large businesses. There's just so much that has happened in the last 150 years. Like if you go turn of the century, in the turn of the century 1900s, the world was a very, very different place. Child labor laws didn't exist. The right to unionize didn't exist. Unions existed, but you didn't technically have a right to it. And the way that unions continued to exist was through physical intimidation and blood, to be blunt. And then laws were passed, and now there are workers' rights. Civil rights was not a thing until it was. The world, and specifically the U.S., has changed drastically in the past 150 years. And anyone that's trying to claim that it's just business doesn't know what they're talking about. And to be blunt, should be taken to court and be forced to take their medicine. Because people like this should not be anywhere near a situation where they can do this again. It's not okay. If you have seen the fallout that's happened in the VTuber community because of this, there is so much more bad that has happened because of the situation than just the money that these people have lost. And there are a lot of people that I think, in my opinion, allegedly legalese, could claim that they were damaged by this economically. But the courts will only fix the economic damage. That's it. The loss of trust, the loss of respect, the damage of relationships, that's not something that the courts will ever be able to deal with. And it has massively affected the VTuber community in the same way that, I guess it's been like 3 or 4 years at least now. If you remember the whole Satine Phoenix thing that rocked the tabletop community, it's massively affected a lot of different things, whether it was artists, writers, live play creators, even things like D&D in a castle and other things like that were massively hurt by one person that was not just doing business. They were violating, in my opinion, they were violating laws. They were committing civil torts and things like that. But the courts will only ever be able to deal with money effectively, especially when we're dealing with civil stuff. The only thing they can fix is money. And even then, they can't make money magically appear. If the person that you're suing gets a judgment against them for $1 million and they have exactly $10 in their bank account, guess what? It doesn't matter how many times the judge says, you have to pay them $1 million. They don't have $1 million. They will never have $1 million if they only have $10 in their bank account. I'm just gonna go on a limb here saying they're never gonna have $1 million. I might be wrong, but I'm pretty sure never gonna have $1 million. So the courts can only go so far, but they are there. They are something that can be used to prevent something like this happening again, because once a lawsuit goes through, that becomes public record. It becomes something that people can look up. It becomes permanently attached to the person that it was filed against, especially if they lose. So, yeah, again, this is not me telling anyone what they should or should not do. This is me specifically talking about this is not how businesses work. And there are remedies for people that do things like this. But it requires talking to a lawyer. And if anyone else is out there watching this thinking, I've got this great idea for a way to make my business succeed and another one of my competitors do poorly, maybe wait a minute on that, because there's a very good chance if you have this idea and go, I don't understand why no one else does this. This is perfect. It's probably because there's either an actual criminal law preventing anyone from doing it, or there is common law that exists that means if you do that, you're going to be sued into oblivion, like tortious interference claims. So, interested to hear from you guys. First of all, are any of you guys aware of this stuff going on? I'm not a huge VTuber fan. There's a couple that I watch fairly regularly. I like Shy Lily. I think she's really, really funny. I'm a big fan of Iron Mouse. And a couple of her friends I think are pretty cool as well. But beyond Iron Mouse and Shy Lily, those are really the only two VTubers that I watch their stuff regularly. Yeah, do you guys care about VTubers or anything like that? And did you find this interesting? Like I said, what's happening to these people is horrible and disgusting, and it shouldn't have happened to them. And I feel incredibly bad for them, and I hope that they're able to get through this as well as they possibly can. But there are things that we can learn from this. They shouldn't have to learn this way. And it's not their fault that this happened. All the victims of this, they didn't ask for this. They didn't do anything that made them easier targets. Nothing that happened is any of the victims' faults. This, in my opinion, was a choice that was made by a single individual, and no one that was victimized from it should in any way think that if I had done something differently, maybe this wouldn't have happened to me. No, it's not your fault. You did nothing wrong. You were unfortunately a victim of someone allegedly doing something bad to you. It's not okay. It's not fair. But we can learn things from it. If something bad is going, if something bad happens, in my personal opinion, it's an absolute travesty if we don't try to learn something from it. And again, that's not me saying, oh, well, the good thing from this is, no, there isn't a good thing from this. This is a bad thing. However, it's a bad thing that we can learn from. So don't twist my words. Don't make people think that, oh, he's saying that something good could come. No, nothing good. Even if a lawsuit actually happens and justice is served, whatever your idea of justice is, if you guys believe that justice gets served from whatever happens, I still don't see that as a good thing. I see that as a just thing. And there's a difference between justice and goodness. Goodness would be this not happening. That ship is sailed. This can never not happen because it already happened. And unfortunately for us, time is linear. But despite the fact that something truly horrible, bad happened, we can learn things from it. And maybe from learning about tortious interference, somebody watching this can realize, holy shit, something similar happened to me, or my boss talked about doing this to another person and I always thought that it was kind of scummy. Now I know it's actually a civil tort, and we can work toward making sure that this doesn't happen again. So, like I said, interested to hear what you guys think. Was this an interesting topic, or was this just a really boring hour-long video? Let me know in the comments down below. Otherwise, again, it's all for me today. I will see you guys next time. All right? Bye-bye.